This case management conference is in the matter of CFI 064-2025 and is being held by way of video conference before His Excellency Justice Thomas Bathurst, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by BSA Ahmed bin Hazim and Associates. Lead counsel is Mr. Antonius Dimitrakopoulos. The defendant is represented by Dentons & Co. Lead counsel is Mr. Stuart Adair. Thank you, Your Honour.
Thank you. Mr. Dimitrakopoulos, I have a number of questions concerning your case management information sheet, which I think is at page 177 of the case bundle.
Yes, Your Honour.
If you wouldn't mind going to it, in paragraph 11A, where it first appears on page 180, you say you intend to rely on 3 witnesses, and then where 11A appears the second time, you say you're going to rely on 2. Whilst I realise you can't make a final decision at this stage, what's your present position?
We are not 100% certain. I apologise for the contradiction. I think we should stick with 2.
Very well. And they don't include the claimant.
They do include the claimant.
Well, the claimant's not referred to there. If you go to 11A, where it appears twice.
Okay, let's go to you are at page, Your Honour.
180. 180. Yes. Paragraph 11A.
Oh, apologies. Sorry. Yes. So this is the case management information sheet. Correct?
Yes, that's right.
Yes. So apologize. None of this is correct. The reason is because, frustratingly, the case management information sheet on the court's portal has got preloaded information from some other case that's got nothing to do with us. And whilst I painstakingly went through with replacing the text in what has been bizarrely preloaded, I must have omitted to delete the reference to 3 witnesses and those completely relevant names that have got nothing to do with this case. I do profusely apologise. I profusely apologise, but it was a constant trip up by having to delete preloaded a text and refilling it with what was relevant to this case.
Well, can I ask you this then?
Yes, of course.
You say that you propose to call 2 witnesses or 3 witnesses.
Well, let's say 2.
And is that the plaintiff plus one other, the claimant plus one other?
Correct.
Very well. And then if I could go across, and this could be the same problem.
Yes.
If you go to 11E where it appears twice. The first one is, do you wish any witness to give oral evidence by video link? You say all 3 witnesses would require video link. And then 11E, you say none. Again, I'm not too concerned about the errors, but do either of your witnesses?
I think, right. So how many of us have intend to rely at trial? 2, okay. So no, they are both perfectly happy to physically attend in Dubai.
I think probably a lot of my questions are going to relate to the same sort of problem, but paragraph, page 182,
Yeah, again, completely irrelevant. Yes, this is not correct. It's the 12A is correct, but 12A again repeats itself. It's exactly the same question. I have no idea why the same question is repeated, but for some reason, an irrelevant text has been replicated. And yes.
Just dealing with that.
Mhm.
The first 12A says an expert in the field of forensic investigations on banking transactions and regulatory compliance.
Yes.
Do you want a handwriting expert?
Since meeting that deadline, which was a week from today, yes, we are of the view that a handwriting expert would be relevant, and indeed we would like to produce one, as does the defendant.
I understand that, but why do you need an expert in the field of forensic investigations on banking transactions and regulatory compliance?
Why? Because the issues in dispute, which I assume Your Honour is familiar with, relate to the fact that we say the bank was negligent in preventing the disappearance of our funds. And in order to prove that, we would need to obtain the evidence of an expert who would determine, first of all, what control measures the bank needed to have in place, and secondly, whether those control measures were specifically applied in the case of our client and in the case of the specific transactions that she disputes. So I would say this is the heart of the matter.
In relation to that, I don't think, and I may have not read your defence carefully enough, you've given any particulars of how it is that the bank failed to comply with regulatory requirements or banking practice, which resulted in the loss your client claims.
Well, we have made clear reference to the two DFSA findings against the bank and against the claimant's relationship manager, both of whom have been fined with millions of dollars for failing to observe the exact measures that would have prevented the disappearance of our clients' funds.
That may be, but I'm not minded to permit an expert at this stage. I'm not going to entirely rule you out of it. And you can make an application, but any application you make should give particulars of the manner in which you say the banks failed to comply with regulatory requirements or failed to comply with banking practice, and how those particular matters caused you loss. And if in those circumstances an expert's warranted, then I'll permit you to have one. But generally, at the moment, I'm not prepared to make any order of that nature at the present time.
Well, Your Honour, it is very difficult for us to know exactly what measures have been omitted. All we can deduce is if the funds were allowed to disappear from our client's bank account, there must have been some fundamental omission on the part of the bank and possibly on the part of our client's relationship manager, a very hint of which we can deduce from the fact that the bank has already been fined for similar failures. We just need to prove that those failures applied in our case as well.
But that involves identifying the failures which occurred. And that's not a matter of expert evidence, I wouldn't have thought.
Well, from our perspective, it should be sufficient to argue that some failures must have taken place. We can't know exactly what because we're not in the bank's books. It is impossible for us to identify exactly which failure.
I mean, it may be, and you could run a case which says, in effect, that because of what happened, the bank failed to take proper precautions to prevent it. I understand that. You can either rely on the fact which happened, or otherwise you identify some proper precautions. Now, I'm not going to force you to do it either way. It's your choice, effectively, but it has to be one or the other.
Would respectfully submit, Your Honour, that we're not in a position to identify exactly which precautions were not taken. We can only deduce.
How can you possibly say then the bank was negligent? You can't say it's negligent and not give any particulars of the negligence.
Well, we say it's negligent because we did not sign and authorize the particular transactions. So when we are advised not...
If that's your case, that's your case. If the case is this, I'm not going to try and put words into your mouth, but I just want you to think about. I'm not going to make an order for experts now, but if you're making an application, I do need to know what particular areas of banking practice or regulatory requirements you say were breached, and how it caused loss. Once you do that, you can then perhaps have some expert evidence, and you don't need to do it now. I think you've got enough to have, apart from standard discovery, an application for production of specific documents relating to the bank's practice. But at the moment, I'm just not prepared to make any order for an expert to give it evidence on. I'm not quite sure what.
All right. So would Your Honour be amenable to the following? That we proceed with the normal steps, and after completion of the document production stage, we can file an application for the appointment of an expert, perhaps on the basis of what has been produced or not been produced on the part of the bank.
Yes, I'll contend with that. Mr. Adair, do you say anything contrary to that?
Your Honour, no. My concerns, what I was going to say, actually reflect Your Honour's concerns, that I could not see how, on the basis of the pleadings at present, one could possibly identify an expert that was going to assist the court. I mean, there is a question as to whether the court needs any assistance with an allegation of negligence in any event, but that's a separate matter.
That's a matter I'll be considering when it comes to deal with any application.
Yes. Your Honour, of course. So, on the basis that my learned friend will make an application in due course, that I'm perfectly content with that. All I would say is, Your Honour content to make at this stage a direction for expert evidence on handwriting analysis and comparison?
Yes, I am.
I'm grateful.
And likewise for the claimant, I assume, Your Honour.
Of course, for both parties, yes. Now, the other thing I want to ask, and this really goes to both of you, as the case seems to me to be presently constructed, I have difficulty even looking at it proceeding on the most leisurely basis, that it would take 3 to 5 days, much less 5 to 6 days. There may be a limited amount of oral evidence, but a great deal of argument as to the extent of the bank's responsibility having regard to the contractual documentation on which it relies.
Would you like me to address Your Honour on that?
Yes.
Yeah, Your Honour, my thinking on that was that we were going to spend a day shared between us opening. We didn't think that our evidence was going to take more than half a day. We haven't identified witnesses. We're having to look back to who in the bank is able to give evidence of what happened 12 years ago. But we will produce a witness. We anticipated more witnesses coming from the other side, so I assumed that perhaps the evidence of fact might take a maximum of 2 days, and then there would be half a day for expert evidence, which is going to be short because it's fairly binary, are these her signatures or not, and then maybe a day and a half or a day for final submissions. So that came to 5 days, and that was my thinking.
Now, just going to drafts timetables, and it's convenient to deal with yours, Mr. Adair, with the amendments, which I think is at page 151 and following of the case bundle. You both can go to that.
Yes.
Firstly, Mr. Dimokropoulos, what's your attitude to the request that a rejoinder be filed?
We think it is totally unnecessary, if not absurd, Your Honour. This case has been pleaded ad nauseum. It's a very simple, straightforward matter. The issues are quite crisp. We say the bank has been negligent. The bank says it's not. And it also alleges that somehow we are time barred, even though this is a claim in negligence. So for it to be allowed yet another pleading, to argue from what can I deduce from my learned friend's skeleton argument is yet another argument of statutory negligence, which has already been pleaded in its defence.
Well, I mean, Mr. Dimokropoulos, can I cut across you? As far as I perceive the position, that irrespective of whether Mr. Adair files a rejoinder or not, you'd be entitled to raise this particular issue. If you accept that, then there's no need for a rejoinder.
Sorry, which issue, Your Honour? The issue of statutory time bar?
The issue raised in the skeleton argument as to the reason for a rejoinder.
No, I don't accept that. It's already been pleaded. If Your Honour goes to the hearing bundle at page 76 and 77, there is an extensive analysis of what the defendant thinks are the reasons why we are statutorily time barred. And I see no reason whatsoever, not only to delay the process with yet another pleading, but to open an opportunity for a response pleading from our end and be locked into an endless loop of pleadings. It is utterly unnecessary in our respectful submission.
Go to paragraph 22 of the skeleton argument. So that's Mr. Adair on page 173. Do you accept that, as the pleadings presently stand, that the defendant will be entitled to raise that issue?
Sorry, you're asking me, Your Honour?
Yes, I'm asking you.
No, I do not accept that. They've already raised it. Nothing changes. To put it simply,
if they've already raised it, if they've already raised it, they've raised it, they can deal with it. If they haven't raised it, why shouldn't I allow them a rejoinder to raise it? It's only a question of construction.
Well, of course, if Your Honour considers that despite my submissions, they have not raised the argument,
No,
and I'm wrong to say so, then of course Your Honour may be inclined to allow it. But our position is that...
Mr. Dimokropoulos, I'm probably not making myself clear. In my view, the issue referred to in paragraph 22 is already a live issue on the pleadings. If that be correct, there's no need for a rejoinder. If it's wrong, and as I understand it, you to say it was wrong, then I would be minded to order a rejoinder. It's better for you. I mean, do you say it's raised or not?
Maybe I haven't been clear either. The issue, live or not, has already been debated and has already been answered. There's nothing further to debate, absolutely nothing to plead. All that the defendant proposes to plead is that if you're saying you didn't sign Form XYZ, I deduce that you accept that you've signed Form A, and if you sign Form A, you have been somehow time barred. This is basically what it wants to articulate, which has already been articulated in its defense for all the forms that we are supposed to have signed. The fact that one of them survives our denial of having them signed doesn't change the argument in any way, because the initial argument by the defendant encapsulated all the forms. The fact that only one form survives now because we deny signing the others doesn't change the argument.
not sure how that answers my question. I think the safer point is to avoid this debate being raised at the trial. I'm going to grant leave for Mr. Adair to file a rejoinder solely dealing with the matters in paragraph 22 of the skeleton argument.
I'm grateful, Your Honour.
Now, just going through the documents, I'm not prepared at the moment to make orders beyond a progress monitoring date, which I think is desirable, in paragraph 14 of the amended consent case management order. That's because I'm somewhat uncertain as to the number of witnesses, the extent of factual issues, relevantly whether this case will be heard virtually or in Dubai. In relation to the orders, Mr. Dimokropoulos, I think I should say this to you, that regardless of which of the two consent orders, which of the two set of directions are adopted, they end up having a trial hopefully within 1 month of each other, either in June or July, which I don't consider of very great significance. So what I'm minded to do, unless you wish to convince me to the contrary, is have the orders that are in paragraphs 1 to 13 of the draft consent case management order, which commences at page 151, add an order that that the claimant has leave to apply for leave to adduce expert evidence on banking practice and regulatory requirements on or before the 1st of March 2026. That gives you time after the production application is done. And if that application is made, I'll make directions as to submissions in reply and for determination. Now, I'll have a progress monitoring date. It'll be listed on the 14th of May, and I haven't picked a working day in the saying that. That's order 14. The 14th of May, and at that stage, I'll arrange with the registry to fix a hearing date and make consequent directions as to the trial. Now, does either of you gentlemen want to say anything in opposition to that?
Your Honour, I would say anything in opposition. I'm very content and grateful for that. All I would say is, looking at, we sort of amended what had been proposed to us by the claimant. I assume Your Honour would wish us to then insert into this the leave to file and serve a rejoinder, which isn't in this at present.
Yes.
And that
should be done within 7 days.
I'm grateful. We'll do that within 7 days. And the other point was, no, I think that's it, because we've got the expert evidence for handwriting analysis. So we merely insert also the leave to for my learned friend to apply for his expert evidence. Yes, no, I'm grateful. No points.
Mr. Democropoulos?
Okay, there's a number of issues. First of all, yes, the point has been decided now on rejoinder, but it was not mentioned in the track changes version of the defendant. So that needs to be inserted. My request is to deal with 2 points. The first one is that the rejoinder period, whether it be 7 days or otherwise, run in parallel with the first stage of document production and not consequentially or sequentially to that. There's no reason why the two can't run together.
But I agree with you, but that's the reason I said that it should be done. The rejoinder should be filed in 7 days.
Okay, great. Now, that's
exactly the reason I said did it quickly.
All right. The other point that I think is a bone of contention between my learned friend and us on behalf of the claimant is the period of time that the defendant says it requires to engage into the first step of document production. It basically seeks 1 month from today, more or less, to basically produce documents it should have produced even before this action was filed when we requested them, and documents that should be perfectly available within the organization of the bank. Given also, Your Honour, that when it comes to document production, this is probably likely to be a one-way street. I mean, we don't have any documents really. So it's going to be just the defendant submitting documents. And I don't think that it requires a month from today to do so. I think 2 short weeks are more than enough for it to either tell us that it has or doesn't have the documents that it needs to rely upon its defense. And then we can move on with the steps after that. And the other short point I'd like to make is that if either party finds it necessary to make an application for a request to produce, that application be deemed as an ordinary application, not a heavy application, regardless of what it seeks. It will seek the production of documents. And that therefore we control the time frame. So it's a 14 days plus 7 to deal with that application as opposed to a 28 plus 28. So if we can build that into the CMC order, that would also truncate the process a little bit. So just 2 points. Number one, not 1 month to produce documents. And number 2, if a request to produce application is required, it should be an ordinary application.
Why do you need till the 11th of December to produce the documents, Mr. Adair?
Your Honour, because this is going back to 2013, because the number of people involved in this are no longer employed by the bank. So there is going to have to be searching of email accounts, which are not active anymore, which will have to be found on servers. And because the bank is going to have to delve into its archives in order to find these documents and give adequate disclosure. In those circumstances, in my submission, it would be unrealistic to say that we can do this within 2 weeks. And in my submission, the purpose of the engagement between the parties is to produce a realistic and workable set of directions, not one that I'm sure my learned friend, who doesn't have to produce any documents, he says, is perfectly happy to put the maximum amount of pressure on us to produce documents very, very quickly. But I'm not sure we can do that. And rather than going back to the court and saying, okay, we need more time, it seems sensible to have a proper, realistic date. But also, I would say, since Your Honour is setting a progress monitoring date of the 14th of May 2026, and we're then going to come back and decide about the next stages and where we go with the trial, I'm not sure what difference any of this is going to make in the longer term.
What about the application for reduction not being a heavy application?
Well, Your Honour, I think you have to treat every application on its merits. It may be, it may not be a heavy application. We'll have to wait and see. I
right.
To prejudge whether it's heavy or not.
Mr. Democropoulos, irrespective of which timetable is adopted, my view is this case will be heard at around the same time, whether it's June or July, may be a difference. I propose to give Mr. Adair the time he seeks for production, because it does go back a long way. There's force in that. And it's preferable that he does it within time, rather than coming back and requesting further time, which will only further delay the proceedings. I should indicate that I'm not likely to, having given him till the 11th of December, I'm not going to be particularly sympathetic to any further extension of time in relation to that. So I think I'll leave it at that. In relation to it being a heavy application or otherwise, Mr. Adair is correct in saying it depends on the particular application which is made. But having said that, I would take a great deal of persuasion to be convinced that an application for production of documents is a heavy application. It should be able to be done very shortly and on the papers quickly. So whilst I'm not prepared to make an order at this stage, what I've said is recorded on the transcript, and it will be taken into account.
Understood, Your Honour.
Very well. Now, can you gentlemen liaise with the registry to get a form of order to take into account what I've said today?
Your Honour, yes, just to be clear, we're looking at the draft consent case management order at page 151, and Your Honour is content with the dates that are in that, i.e. the amended dates using track changes. And that's the order that's going to be made.
That's right, yes. And with the additions
we've discussed. I'm grateful. That's helpful. Yes. No difficulty, I don't think, with us liaising and producing a clean copy of the order Your Lordship, Your Honour will make.
Yeah. Mr. McCrory, have you got any more to say?
Yes. So when it comes to expert evidence, there is a date here for the reports of the experts to be exchanged, the defendant says, on the 7th of May.
Yeah.
Does that still stand, or?
Yes.
And 4 days after that, we had to have a progress monitoring date?
Yes. 7 days after that.
14th, 7th. Yeah. Okay, so the only thing that is in parallel really is the production of the rejoinder as probably the first step.
Yeah.
Which should run in parallel with standard production of documents.
Well, it's done.
And the remaining amended dates Your Honour adopts and would like included in the final version of the order.
Correct. That's correct.
And we stop at the progress monitoring date and go no further. Is that correct? That's correct.
That's correct.
Right.
Your Honour, presumably costs in the case.
Correct.
Cost of this case management conference in the case. Yes, I'm grateful.
Can I just add one point? I'm concerned that if a trial date is not at least penciled in, if we're going to determine it as late as 14th of May, a lot of the dates that are now available may simply be not available on the 14th of May. So the whole purpose of the draft exchange was to at least pencil in a potential trial date.
The reason I'm hesitant is that if it doesn't appear to me to be a substantial factual matter, I'll hear the case virtually. If I hear it virtually, you'll get a trial date very quickly.
Understood.
That's the reason.
Understood. Because I was going to say that this has also may have an impact on the availability of witnesses to be physically present one day versus another. Well, but if Your Honour is inclined to also consider a virtual hearing, that makes matters more flexible as far as the date of the trial is concerned.
Because that was what I was going to raise with both of you gentlemen, that whether you have any particular, and I'm not asking for an answer now, because it's probably premature anyway, whether you have any particular objections to the matter being heard virtually, which will get a quicker hearing.
My position, Your Honour, would be, I think, rather like Your Honour's position. I would want to see what the factual evidence is, the extent to which cross-examination would be important, relevant, before I gave any indication in that regard. I mean, in principle, I've got no objection, but I would want to know what we're dealing with.
That's fine. I accept it. I'm not pressing anyone to make a firm answer at the moment, but that's something I think you should consider.
Yes.
All right. That's been very helpful. Is there anything now either of you wish to add?
I don't believe so, Your Honour. I'm just checking my checklist, if I may, just to check we've not. No, I think Your Honour has dealt with everything. I'm grateful.
Mr. Micropolis?
No, I'm likewise of the view that everything has been addressed. We had also had a look at possible public holidays that may interfere with certain dates, but we haven't been able to identify one until the 17th of June, which is the Islamic New Year break. But yeah, I mean, I think everything else falls nicely into place. Having said that, we haven't double checked the dates that the defendant proposes, but there might be a small shift.
If there's a shift around the edges that you agree to, I'm not going to have any. You don't have to come back to me with that. Just one other matter, more in hope than expectation. Is it worth the parties having a mediation? I know you said no, but is it worth the parties having a mediation in this case?
I obviously, is a matter that is always raised on a case management conference. I took instructions on this. My instructions are that at present, the views of those instructing me and the client is that it isn't appropriate at this stage. But Your Honour, we will obviously keep that under reference, and if matters change, then obviously it will be a course that we will we would pursue.
Mr. Micropolis?
We're not in favour of any structured or otherwise mediation, Your Honour, if it will delay proceedings. So anything that can run in parallel, we're of course open to. We just want our money back, essentially. But we do not want any process that seeks to achieve that, delay the actual litigation.
It's my practice, both here and in a past life, to the extent I sat in trials, not to order mediations if they had the effect of delaying the ongoing progress of the case. So you need to worry about that.
Well, in that case, we're always open to any kind of proposal from the defendant.
Well, I'll leave it at that. Just recommend that you consider it.
Yes, we shall. Thank you.
Thank you. Very well. Well, I'll adjourn until the 14th of May, or until anyone else makes an application in the interim period. Thank you.
I'm grateful. Thank you, Your Honour.